I'm going now to introduce someone who is a great friend of the Trust Women and Trust Conference, and she was on my advisory board. It's Livia Firth. Livia Firth is now going to speak of a very big research, legal research, that has been done in, I think, more than 12 countries, 15 countries, on living wages. And this is a notion which is not, I mean, it's not exactly slavery, but living wages is something that people need to be able to live. So Livia, everybody knows her. She's the director of EcoEdge, the creative director of EcoEdge, and a founding member of Annie Lennox, The Circle, a powerful women's advocacy group. Please come and explain. The research was done, was organized through Trust Law, so it's again part of the family.
It is indeed, and it's really nice to be here again. We have long been in search of a breakthrough around slave labor and labor rights injustice in the global garment industry. And there is now a very, very strong feeling that we've been debating, negotiating, discussing the very basic of human rights, the right to a living wage, for far too long. The ready-made garment industry stands as the poster child for exploitation. In an increasingly globalized world, companies source goods from factories where people work in conditions and for wages that would be illegal, if not criminal, in the main marketplaces where those goods are sold. As member of The Circle, a women advocacy group founded by Annie Lennox, as Monique said, when we had the opportunity to put this issue in front of our lawyer circle, a network of high-profile, experienced legal professionals using their skills to progress social justice, we grabbed it with both hands. And they did not disappoint. The lawyer circle has spearheaded a substantive research, taking evidence from 15 major garment-producing countries across the globe by a network of legal professionals based in those countries. Using this evidence and working with industry experts and committed campaign organizations such as the Clean Clothes Campaign and Trust Law as a partner, a team headed by Jessica Seymour QC, one of the UK leading specialists in human rights and public law, joined the dots between international law, fashion industry, and human rights. Our driving motivation was the fact that a failure to implement living wages condemns a workforce of millions to live a life that cannot be deemed decent. Are they technically slaves? Well, I would say loud and clear, yes, because on top of being forced labor, bond labor, trafficking, most of these people are forced and enslaved in a circle of poverty from which they will never get out. I want to remind you that as a society, we shall soon mark the centenary of the end of World War I. Among 100 years of memory, the fact that this marked a seismic shift in terms of labor law might go unnoticed. But in 1919, the idea that there was a relationship between poverty and peace had major traction. Indeed, when 32 countries met in Paris to broker that peace, the protection of wages and the status of labor represented a critical issue. Here we see the foundation of the International Labour Organization, the first legislator advancing a just relationship between workers and employees, and based on the founding principle that you all know, that labor should not be regarded merely as a commodity or as an article of commerce. That same principle was incorporated under Article 427 of the Treaty of Versailles, and as the complex conference progressed, the delegation from Paraguay drew on this absolute rejection of labor commodification to propose the setting of minimum wages. This backdrop is not just a historical footnote. It serves to remind us all that for more than a century, states have recognized the right to wages sufficient to support the basic needs of a family. These are known as living wages, what we call an adequate minimum wage. States have recognized this right through legislation and in some instances even by way of constitutional guarantees. How is it then that we still find ourselves at a point where we are experiencing a revival of the sort of exploitation that those states participating in the 1919 Peace Conference agreed to consign to history. In fact, this exploitation of labor has become part of the global economic model, while the fashion industry is eye-wateringly remunerative with global revenues of $3 trillion. Engineering a breakthrough and making this regulation work is therefore absolutely necessary. And when it comes to living wage in the garment industry, even more so. To date, as you know, efforts to prevent labor exploitation have tended to focus on non-binding measures, in other words, voluntary codes and initiatives designed, implemented, and monitored by the retail companies who control the supply chain, and normally developed in response to negative publicity generated by investigation carried out by NGOs or media. To put it bluntly, this strategy doesn't work. There has been limited impact on labor conditions in general and virtually zero success in improving wages. So the aim of the Lawyers' Circle report was therefore to set the debate on living wage in the garment industry within a clear legal framework. The report, which is very comprehensive, and I hope we will all download from the Circle website or ask Shoned, who heads the Circle here on front row, looks at 15 ready-made garment countries and collected country-specific data in order to ask the question of whether minimum wage legislation in those states provides for a living wage. The conclusions from each allow us to consider the premise of the report. Namely, as a matter of international law, states are obliged to guarantee the fundamental right to a minimum wage, meaning a living wage. There are now strong grounds for arguing that countries that fail to ensure that workers within their jurisdiction are paid a minimum living wage and legally protect their employees from abuse and exploitation are acting unlawfully in international law and can lawfully be subjected to trade sanctions or restrictions on imports. This is a summary of key findings from the report. This report concludes that a minimum wage, meaning a living wage, now constitutes a fundamental human right which states are accordingly obliged to guarantee. In the light of that, we consider that where companies choose to produce or source their goods from states where that fundamental right is not guaranteed, as a matter of law or practice, they must, as a minimum, themselves take steps to ensure that the people who make those goods are guaranteed this right. That is a responsibility that falls on the relevant company, it being aware that the state does not ensure that right. The report also concludes that if the commitment from fashion brands is real, they can and must change now. A large number of companies have already made a commitment to pay a living wage. However, they've generally done so in relation to the future. This report concludes that that is not enough. In that regard, the report notes that where large companies with enormous turnovers and profits frequently state in their published code of conduct, due diligence, and sustainability reporting that they pay the national minimum wage. In the context of garment manufacturing in the main RGM areas and countries, they do this knowing that the minimum wage comes nowhere close to a living wage. Such companies are therefore fully aware that their goods are produced in breach of fundamental rights and established international labor standards, that they are the product of exploitation. Any company that claims it satisfies human rights and international labor standards by paying the minimum wage in a country where that wage comes nowhere close to a living wage has necessarily therefore failed in its duty to ensure such compliance. Put it bluntly, it is aware of its non-compliance. This report does not accept the argument by companies that it is not practically possible for them to ensure that the living wage is paid. Paying the legal minimum wage cannot be a legitimate excuse for failure to ensure that such a wage is at least arguably a living wage. It is clearly open to large companies either to source the goods only from states that ensure that the legal minimum wage is a living wage, and provide for enforcement, exercising sufficient due diligence to prevent subcontracting, or alternatively, to open up their own production units in countries where the legislation provides inadequate protection, and thereby ensure that they are able to pay the people who make their goods a living wage. Lack of clarity or consensus on how precisely a living wage should be calculated cannot be a legitimate justification for paying wages that on no calculation could be said to constitute a living wage. We do not accept the arguments made that as it is not possible to agree precisely how a living wage should be calculated, this is a justification not to pay a living wage. So by highlighting the vast difference in most RGM countries between the legal minimum wage and a living wage, this report concludes, first, that it's not good enough for manufacturers or retailers simply to say that those who produce their products are paid the minimum wage guaranteed in the relevant country. Where the minimum wage does not come close to a living wage, such a claim is an admission that the company's goods are produced in breach of fundamental rights and international labor standards. Secondly, in the near future, some enforcement control mechanism is needed to ensure producers, retailers who choose to use labor in countries where the minimum wage is in no sense a living wage take all reasonable steps to ensure that the workers who produce the goods that they sell are paid a living wage. While self-regulation should be enough, in reality, it has manifestly proved ineffective. This report is a groundbreaking tool to inform advocacy at both national and international level, and to push for concrete and effective action. Legislation, obviously, is only half the story, the inadequacy of enforcement being another significant hurdle, and this report represents a first step. Join us tomorrow morning at 8 a.m. for a roundtable moderated by Lucy Siegel, broadcaster and journalist, Shona Jones, who heads the Circle, Catherine Jones, one of the lawyers who drafted the report, and Carrie Stairs, global head of legal at Thomson Reuters. You need... Why Monique always tells me off? Including she used to be an advisory board member. I'll be again. You need... So you all need to join our next phase of the report, where the 4 major stakeholders, business, government, NGOs, and civil societies, come together to help develop policy for using international mechanisms, including trade agreements, to enforce the right of garment workers worldwide to receive a living wage. We can't be here next year again discussing the same issue. We need both your financial support and your manpower, or women power, to get it done. Thank you.
Thank you. And you're welcome back when you want.
Yeah.